Welcome to the last session of our conference. I am going to introduce Richard Bays. Mr. Bays have served in numerous capacities in the healthcare industry, ranging from clinical services and operations, healthcare bill and policy analysis, medical legal consulting for healthcare attorney groups, and oversight of accreditation, licensure, and regulatory compliance programs. He specializes in economic aspects of healthcare litigation, such as life care plans, future medical cost projections, accounting and tax considerations, as well as reimbursement issues. Thank you for being here.
Appreciate it. All right. All right. You made it to the last session. So it's like the final boss. Before we get started, let me get an idea of who all we have. Who is a nurse? One nurse. Okay. What else do we have here? Life care planners. Okay. Okay. Oh, economists. Good. Any other economists? Good. Very good. Attorneys. Okay. Well, okay. All right. Yeah. So we got a little bit of everything. This is going to be a little bit centric toward nursing, but it does apply to other, other disciplines. Just when I say nursing, just substitute yourself. But I had to pick something. So anyway, I'm a nurse, I'm an attorney, joker, smoker, and all that stuff. Well, I don't know if anybody's old enough to know that joke, but anyway, there you go. We have Steve Miller, man. Fans. That's great. So anyway, we're going to go and get started. I'm going to give you some tips today, talk about expert witness testimony, so you won't pull your hair out. Anyway, so these are about 7 things that I picked out. This is from personal experience from plaintiff and defense. So it's on both sides. These are some of the personal nightmares I've got to live, and I want to share them with other people. There's also some great tips in here too, to help you when you're having to testify. And also if you have to deal with somebody else testifying and your client asks you, what's going on with that? So you'll get to sit there and say, and you can look like a superstar, which is great. So we're going to jump right in. The first thing we're going to look at, I got 7 things I'm going to talk about. The first one's failure to be objective. So can anybody tell me what objectivity is? Right. It's something you're going to be neutral. So you don't want to get involved in the case and take a side. The problem is that the attorneys are supposed to be pushing the case. That's not your role. So you want to make sure that you're taking whatever information you're giving and you're giving a fair evaluation of it. If you're slating the evaluation one direction or the other, you're now moving off the objective pathway. Talked about personal motivations, personal feelings, things of that nature. Sometimes people look at the cases and they're like, this is just absolutely egregious. It shouldn't have happened. This is a horrible thing. This person got injured, and they get a little, on the side of the injured party. I'm not saying that's a bad thing, but it's not in the objective zone. You can certainly demonstrate empathy for people who've been injured, but you want to stay objective because that's what you need to testify to. Anyway, an objective expert, you're going to be looking at everything you have. Let me come over here so I can see better. You're going to be looking at the different materials that the attorney is going to give you. So the attorney is going to provide you with different documents, different things like that, and you need to go through those things. If there's something that you feel is missing, you need to ask for it. I've had a lot of times where the attorney said, look, the hospital's policies, we have a hospital case, the hospital policy doesn't cover this. And I'm like, I don't see a hospital policy in the package you gave me. Well, yeah, but it's not there and blah, blah, blah. And I'm like, yeah, but I need to see it. I can't just take your word for it. So I need to see what I have and then objectively evaluate it so I can give you some type of objective reasoning. Anyway, the jury is going to be able to see if you're pushing for one side or the other. What they want to do is they want to be able to look at this and go, okay, this person says, there's a great example. It's 30 degrees outside. Okay. Somebody down here might say it's kind of cold. I don't like that. But there's somebody maybe from, say, Canada who's like, that's not cold. So is it cold or is it not cold? That's subjective. It depends on the person. The objective item is that it's 30 degrees. So the thing is, you want to tell the jury it's 30 degrees. Let them decide if it's hot or cold. That's up to them. But you have to stay objective with the points that you're given. So you take what you have and you make sure that you're maintaining an objective eye on it. The roles. The attorney is an advocate. If you're a patient care provider, you're providing for the patient. You want to advocate for the patient to make sure they're taken care of, that they're getting what they need, that they're getting all the care that they need and they're due. If you're the attorney, your client needs to get vehemently advocated for, and that's your job. The expert is not there for that. The expert prevents facts and information. Now, the person who's going to make up the decision is going to be your trier of fact, and your trier of fact is either going to be the jury, it's going to be the judge, or somebody else at a tribunal. And those are the people who will be making the decisions, but you're supposed to present the information. Now, if anybody here been deposed? Yeah, deposed, yes. Okay, good. Well, lots of people at depositions, great. Anybody here have friendly attorneys depose you? Couple? Okay, good. That's good. I've had both. So the thing is, it can go either way. The attorneys have a hyper drive for competitiveness to win their case. So it doesn't matter what the truth is. Sometimes it's the goal that matters. So these are extremely goal-oriented, driven people. And depending on what firm and what attorney you're dealing with, the truth may be something that is very, very ethereal to them. So you have to really understand, they're there to do their job. You are the nail, they are the hammer sometimes. So you have to just present your information. And then if there's something that is just looking like this is not the way it is at all, but they're shading it that way, your client, your attorney can rehabilitate that. Okay. So they can bring that back for you, but it's not your job, and one of the classic things I've seen happen, and I watched a guy have a complete meltdown, which is really entertaining. He started screaming at the attorney, that's not what I said. That's not what I meant. You're twisting my words. That's not what I meant. And you know it. And it was really entertaining to watch this because the thing is, the attorney was a real interesting person. Anyway, a real nice guy. And so it was really interesting to watch this guy who probably is, I don't know. I don't even know how to describe the interesting levels of amorphous ethics that he possessed. But the thing is, to watch this and to watch somebody who's just trying to do their job the best they can and watch them go head to head was very entertaining. It wasn't, I'm sure, entertaining for the expert, but again, like I said, I wasn't the guy in the hot seat. Failure to be objective. How can you improve this? Look at all your materials and, don't try to take what the theory is that you want to have. Look at what it says. So if you see a patient care sheet that has vital signs, and the vital signs are every hour recorded, okay, then that's what it is. It's an hourly vital sign sheet, and that's it. So that's all you need to know. You need to make sure you look at it objectively. If the attorney's like, they're checking the vital signs every hour, and it should have been every 15 minutes, well, that's his job. You know what I mean? But what you have and what you can present to the jury is that you have an hourly vital sign sheet. That's it. That's all you can say. Now, they can ask you, is that appropriate for this patient? You can say, oh, hell no, it should be every 15 minutes. There's no way. You should have never waited an hour to check these people. Or you could say, actually, you could have checked at Q shift. This patient's totally stable. They're in long-term care and they don't need hourly vitals. But the thing is, those are questions. But what you're going to say is you have an hourly vital sign sheet. Formulate your opinions based on the evidence that's actually presented to you. So the thing is, don't look at what the attorney or client, their theory is and say, okay, I've got to match the evidence to their theory. Look at what the evidence says and then see if the theory matches the evidence. And that's what you want to do, because if it's the attorney's job to do that, okay, it's his job to make it work, or her job to make it work. But the thing it comes down to is you look at what you have. Compare what you find and compare your client's agenda and see if it even is in agreement. Because I've had plenty of people tell me the hospital cut off the wrong foot, the hospital needs to pay. And I'm like, well, I don't disagree with that, but let's take a look at this, and we look at it and it's like, well, you know what, we had something happen here and yeah, it was bad, but there are some mitigating factors and you need to weigh those into the thing. But what I can say is what happened. I can take the chronology and tell you, this is what happened. That's what I can say. Now, I can't tell you, I'm not in the head of the surgeon. I don't know what he was thinking. I don't know what he was not thinking. I don't know what he should have been thinking. What I can tell you is this is the rule. This is what happened. And that's all I can say. It's his job to come in and say, well, this is the way it happened. And that attorney, their attorney says that the surgeon's a good guy and he's not a good guy because look what happened. That's their argument. Let them argue. But the thing is, you have two attorneys on each side. They're pushing back and forth. You're putting stuff in the middle, which are facts and information. They push back and forth. Their job, not yours. Prepare for potential questions. This is one of the biggest things that really would help. If you're writing a report or you're going to give expert testimony, think about what it is that your client wants you. What do they want you for? They're not paying you to say things that goes against their case. They're paying you because they want to support their case. So what is it they want you to say? Think about that. Now think about if I was working for the other guy and he heard me say this, what would he want me to say or not say? How would he want to describe this? If I said that the patient had, appropriate care and the nurses did the vital signs as they were supposed to, then what would the other guy say? And that's where your real bread and butter comes in. That's where you can do your analysis and say, well, if I was on the other side, I'd say, okay, well, they did this. It says the hospital policy says you must check it every shift. And they did. And so your guy's like, yep, they did it. They're fine. Everything's okay. The other side is going to be, yeah, they checked it every shift, but how often should they have checked the patient? Based on the patient's condition, they should have checked the patient Q15, Q30, whatever it may be. And so you have to think about how the other side is going to go. Well, shouldn't they have checked the patient more often? What if the patient had this? Would the patient need to be checked more than once an hour? Yeah, they're going to ask you these questions, and you can see where they're going with formulating the foundation for that. So anyway, just try to think about what the other side would say to fight back against your testimony. And if you can prepare in that way, especially when you're preparing a report, you'll be a lot more even-handed whenever you go into the deposition, because you'll know what to expect. Next thing we're going to talk about, broad blanket statements and beyond the scope of practice. We're going to talk about these two things kind of together. Again, some more excitement. These broad blanket statements, these are statements that are so large that they are useless. The sun comes out in the day, the moon comes out at night. No kidding. Doesn't really help me if I need the weather report, does it? Do I wear a jacket or do I wear shorts? Well, if you're in Texas, you're wearing shorts. But the thing is, the bottom line is the sun comes out at daytime. Yeah, that does not help me. I need to know what the temperature is today. So something that's a broad statement is virtually worthless. So you need to narrow it to the fact pattern. Whatever the fact pattern is you have, that's what you need to work with. Beyond scope of practice, whatever your practice is, if it's nursing, if it's an economist, if it's a physician, if it's whatever it is, you have something within that scope. Okay. Don't go outside of that scope. If it's something that you like, well, yeah, I know that, but it's not in your scope of practice, don't opine on it. Stay within your lane. That's the best thing you can do. Okay. Statements that are overly encompassing and lacking sufficient detail. This is what I was talking about. There's not enough detail to tailor it to the case. You can't say something so large that it's unapplicable to what you're actually doing. Beyond the scope, statements, they may be correct, but it's not within your education, training, and licensure level. Okay, so I'm a nurse. I have a patient come in and they have congestive heart failure. And it's obvious. I mean, there's no denying it. Anybody with eyes in their head says that's a CHF patient. Okay, I know that, but I can't diagnose that patient with a medical diagnosis because I'm not a doctor. So the thing is, I can give them a nursing diagnosis, but I can't give them a medical diagnosis. It doesn't matter that it's correct what I'm saying. I can't talk about it because that's not my lane. It's causation. Doctors decide about causation. If you're not a physician, you can't really talk about causation. You can point to it, and I've seen people do that and they say, well, this was caused by this per Dr. So-and-so's report dated so-and-so, per Dr. So-and-so's statement and deposition dated so-and-so. You can point to it, but you can't say it if you don't have MD behind your name. So stay within your lane on these things. And let's go ahead and expand on these things. Broad blanket. These are things I've heard and I've seen. The nurses did nothing wrong. Really? That's interesting. Let's try something a little better. The nurses performed routine vital signs as prescribed by the physician orders and in compliance with the hospital policy. That sounds better. The nurses did nothing wrong. I mean, I'm like, they bring up some, I mean, we have these expert witnesses I run across and I don't know where they find these people, but they say stuff like this. And I'm like, that doesn't mean anything. You know what I mean? And this is easy when you get somebody in deposition like this. And I'm like, well, did the nurses check the dietary orders? Oh, I'm not sure. What's the boiler room temperature on the hot water in the basement of the hospital? Well, how would I know that? Well, the nurses know that. I mean, you're saying there's nothing wrong. I mean, what do you know? You can just go off on a tangent, make them look like fools. The nurses followed all the policies and procedures. All of them? I mean, what about the valet out front? They follow that? I mean, the thing is, you can't just sit there and make these type of statements. If you're taking an exam, be very careful if you see something that says always, never, every time. All those different extremely out to one side words. They're usually not the right answer. This is not the right answer. say the nurses followed the policies and procedures according to how to start and maintain an IV in the patient. Go with something that's specific to what's going on. The patient was giving nursing care. I hope they were, but you might want to be a little more expansive on that. The patients were provided nursing care in accordance with American Nurse Association guidelines and hospital policies and procedures when it comes to patient XYZ. That's what you want to do. But you don't want to say that patient was given nursing care. Well, if they weren't, I'd be concerned about that. One of my favorites, hospital followed all CMS standards. I'm like, yeah, well, this is going to be a long deposition because we're going to go through all 500 pages and I'm going to impeach you each time. These are undefendable statements. You can't come up there and say these things. These things are insane. So if you say something like this, any attorney who's, pretty decent, because there's some bad ones, but the ones that are pretty decent, they're going to eat your lunch on this. They're going to make you look like a fool. You're going to look like an idiot and you're going to walk out feeling really bad. So don't do anything to put yourself in a position where you're going to get attacked and they're going to really tear you up because you said something that's kind of, in my opinion, pretty stupid. So make sure that you hone in on things. And we're going to be talking a little more about this in the future. I got a quick question. Does this patient parking lot have adequate lighting? Who says it does? Who says it does not? Okay, I got one no and two. I got a couple no's. Okay. Yes.
I could just see the argument being also like, how does this picture necessarily represent what really happened that day? Because pictures can change what things really look like in real life, right? What is the contrast of this screen, right?
Yeah.
How do we know how that affects the reality of the situation, right? So I could see people getting into that.
Anybody have Instagram? I've seen my cousin without her makeup on, and I've seen her on Instagram. It's different people. They're two different humans. I don't know what she looks like because I know her. But anyway, I'm gonna give you the answer to this. If you said it does, if you said it doesn't, you're right. It doesn't matter because the thing is anybody here an expert on parking lot illumination? Of course not. So this was had an actual case. It doesn't matter. It really doesn't. We had a nurse who claimed that she knew, and this was a lot of fun deposing her. But it doesn't matter. It's not your lane. If you get out of your lane, forget it. The excellent point you made, the screen, the presentation, you can adjust contrast, but it really doesn't matter. A patient did fall in a parking lot, did get injured, had a femur fracture, by the way. Beyond scope of practice. The nursing knowledge of municipal codes for buildings and land use. Nurse tried to say that they understood the illumination recommendations that the municipal codes, all this garbage they tried to spew. And I'm sitting there going, what nursing school did you go to that discussed this? Could you tell us? Because I don't know any nursing school that has municipality codes in it. What advanced nursing certificate, degree, or education did you receive that talked about or discussed or even pointed to municipality codes? And the answer is none. So the thing is, you're not an expert, are you? Just admit it if you're not. I had somebody ask me one time about have you ever been a security guard? I said, no. Have you ever been a police officer? No. Are you an expert on security in the hospital? I said, with regards to what Joint Commission and the state requires, I am. I said, beyond that, no. And they said, so you're not a security personnel person. You're not an expert on that. I said, of course not. I never said I was, never held myself out to be. Just admit it and say, I'm not. But this person's like, I know everything. If it's got to do with the hospital, I know it because I work there. And I'm like, you're crazy. And she didn't look too good at the trial. RN declaring medical diagnosis, kind of alluded to this earlier. If you're an RN, don't do something that MD does, vice versa. If you're MD, don't try to practice nursing. RN decision of the prescription of therapeutics. Again, if you're an advanced practice nurse and you have a license to prescribe things, you can talk about it. If you don't, do not. If you're an LVN or LPN, please do not. Specifying treatments, you have no education, training, or experience. Had a nurse. She's been working in a nursing home for 29 or 30 years and decided to write an expert report on a NICU patient. And I said, what do you know about NICU patients? And she goes, well, I know a lot about them. And I said, where did you learn about that? I read a book one time. I said, how long have you been working in a nursing home? 29, 30 years. You ever worked anywhere else? Nope. I do rehab. She had some kind of functional rehab assessment thing she did at the nursing home, worked with PT, OT, all the ST, all these people. And that's what she did. And I said, then why are you talking about NICU? Well, I'm a nurse. And I'm like, okay, well, I drive a car, but I'm not a mechanic. So if you want me to rebuild your transmission, you're probably going to die. But you know what? I drive a car. So it doesn't work that way. That's not how this works. Specifying treatments that you have no education, training, or experience. If you don't know anything about this, don't make an opinion on it. You know, if you want to go get educated on it, that's fine. You know, go out and get a certification, take a class, you know, go work at a job somewhere, get the education. Comment on policies you're unfamiliar with, you have not reviewed. Don't talk about policies you didn't look at, because they're going to pull them out and slap them up on a screen like this, and they're going to make you look like a moron. You know, it's like, if you haven't read the policy, ask to read it. You know, if you haven't received it, ask to receive it. If you don't get it, don't read it. But don't talk about it if you haven't read it. And, you know, we see a lot of this stuff going on where people are just going way outside of their practice, you know, to try to, like, well, I got this client, I want to make them happy. Well, you know, they asked me to do this. I don't want to let them down and disappoint them. Well, you know, I mean, I don't want them to not hire me for the next case. And so they do stuff that they should not do. So whatever you know and whatever you do, hey, you're the expert. But if it's outside of that scope, don't try to get into it, you know, just to save, you know, the case, because I want to stay on the case. Just tell your client, hey man, I don't know, you know, I can't help you with this. Let me see if I can find somebody, you know, let me check with somebody and see if I can help you. How do you avoid these errors? Broad blanket. Look at the exact points in your written report. You know, you might write a paragraph. You know, thinking about law school is like, you know, they teach you how to sit there for 8 to 12 hours to write one paragraph. You know, look at the points you make in your report. See if they actually support the evidence you have. See if they make sense. Do they address the issues of this case that you're dealing with? You know, this patient has a TBI, they can't walk too well. You know, they got some problems, you know, getting in and out of the chair. You know, does it have something to do with that? Or are we talking about something else? You know, I mean, if it doesn't have anything to do with what's going on, then, you know, stay away from that. Look for overlapping issues and look and make sure if there's detailed support. Here's a boiler room. If you don't know anything about boilers, don't talk about them. There's flight nursing, flight care. If you don't do that, don't talk about it. You might say the patient was airlifted from facility A to facility B. That's fine. That's a fact. It was on this day at this time. That's fine. But don't talk about, you know, well, they hang lactated ringers and they shouldn't have did that in flight, because everybody knows if you look at this, you know, the constant here, you know, look at PV over NRT and you see that, you know, this is the wrong fluid. Don't do that. If you don't have a certification in this and you haven't done this, don't talk about that stuff. Don't pull something up on the internet, pull out an article and say, I'm an expert. Don't do that. Stick with what you know and you'll be fine. Beyond your practice statement, you know, are the issues within the scope of your license? If you're licensed to do something or you have the experience or education, whatever it is, stay in that lane again. This might sound familiar. I might have said that earlier. Do you have the education, training, experience to address these issues? It might be something, you know, I can't talk about this. If somebody came to me and told me that, you know what, we got a patient who's had, you know, 17 brain surgeries and all this other stuff because they had an explosion at a chemical plant and they need to do X, Y, and Z. And I'm like, that's a little, you know, far from me. You know, I'm more of like, you know, maybe stroke people being rehab. That's more my lane. Then I'm going to stick with that and say that's a little more advanced. You need to get somebody with a little more background. Is this area you normally have within your scope? If it's something that is like, you know, I've worked, like the lady who worked in the nursing home. She does rehab and works in a nursing home. She's been doing that for like 3 decades. It's all she's done. So would you want her to talk about dialysis? Probably not, because she doesn't deal with dialysis. So the thing is, you know, you want to make sure it's something that's within the normal thing. Now, if you have a patient, let's say they have like a stage 2, you know, wound ulcer, you know, a skin ulcer, something like that, and you want to talk about that, and you're dealing with that thing, you know, somewhere in your practice, that's okay. But if you're doing paperwork and you're doing filing Medicare paperwork like MDS or something, and you don't see patients, don't start talking about skin ulcers. Don't start talking about that, because that's way outside of what you normally do. You may be qualified to do it, but you haven't done it. So try to talk about it. No qualifications to opine. If you're going to make an opinion about something, it's really important to be qualified. If you're not qualified, you're going to have a whole bunch of problems because they're going to eat your lunch. And the thing is, you want to make sure you have some way to say, look, this is what makes me the person. You'll have the other opposing counsel a lot of times ask you straight up. They'll sit down, do pleasantries, do all the stuff. You enter into the deposition. Now, Mr. Bays, tell us what qualifies you to opine on this issue today? Oh, Well, I'm a registered nurse. I'm licensed in the state of so-and-so. I have this certification. I've been doing this for so many years. I've taken care of these patients over these, this many year, this year, I'm familiar with the rules and regulations of blah, 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 blah. You can sit there and you can explain and articulate. Think about like a job interview. It's like, welcome to your job interview. Tell us about yourself. Wow, you're hiring and I need a job. Okay, well, that's probably not going to do it. When I was in high school, I had a job, like a lot of people probably here did, and I was looking for a better job because I wanted to make more money because we were paying about $3 and something for minimum wage back in the Fred Flintstone day. And so I went and I wrote up something and I looked at my paycheck and I saw that the place I worked at, they had a parent company. And it was really cool. And it was like, I don't know, like Fastway Systems or something. I said, that sounds a lot cooler than the name of the place I'm working. So I put that on and I didn't know what a resume was. I'm trying to figure this out. So I wrote it up. And I said, I got to describe what I'm doing. So I got real creative. And I said, I'm the manager of a supply chain that prepares and distributes products to customers. I said, that sounds good. I'm going to write that down. I got a job interview. I walked into the job interview. The guy, look at this. It's really nice, But he's looking at me. He's like, you look kind of young. So maybe you could tell me a little more about this. I said, oh, it's real simple. I said, people place orders for products. I said, when they do, I said, the order's given to me. I said, and I'm the one who supervises and actually puts my hands on the products to prepare them. I said, and then we distribute them to the customer. I said, it's a throughput supply chain. He said, why don't you tell me what it is you actually do? I said, customer orders the meal. I cook it, and then I slide it through that slot, and they put it on a tray and give it to them up front. He said, you cook hamburgers at a fast food joint? I said, yes, sir. I said, that's one way to put it. But you know what? It sounds a lot better my way. So, production and distribution of customer products, that sounds better. But the thing is, I'm not saying to get crazy on this on qualifications to opine, but you might want to be able to think about how to sell yourself, how to articulate, why am I the person you should talk to? Why am I qualified to sit here? Well, I have this license. I have this experience. I have this training. I've done this, I've worked on 12 of these cases in the past. Whatever it may be, I don't know. Just have to figure out what it is. Claiming unearned credentials. This is really amazing to me in this time in history that people will, and I've caught people in this, tell me that I'm a physician. And I'm like, no, you're not. I'm a nurse. Well, the nursing board's never heard of you. It's amazing that people would do this. I don't think anybody in this room would do this, but you're going to probably see some of this if you are around long enough. You're going to see people claiming crazy stuff that they're not. And if you have something, you should be able to produce it. If there's, if you go to the board of nursing, you can punch my name in and pull my license up. That's easy. You can validate that. That's not hard. No experience relevant to the case. I've been working in dialysis for 26 years, not really, but, and I'm going to sit there and tell you about, I don't know, the cath lab. I don't know anything about the cath lab, but in dialysis. So, I don't have any experience that would give me any standing, but the credentials, you're going to see us a lot. People say, I'm certified to do this. I'm certified to do that. If you get called out on that, you're in a lot of trouble because it's not just like you're probably gonna get fired, it's perjury. So you don't want to get in trouble and have a really angry judge yelling at you. Could actually cost you money. So don't, not that anybody here would do it, but be aware other people do. I've seen a lot of people claim all these crazy things. I've had people make up certifications and I've like Google looking for it and I can't find it. And I'm like, who gave you that? Well, so-and-so did. And it's like, that organization doesn't exist. And so they just make up crazy stuff. I've got an MSN and a PhD. I'm like, where you got the PhD from? From a university. And it's like, and I'm like, I can't find them. And so, and that's what happens. You use that all the time. There's something called LexisNexis and Westlaw. These are two different services that attorneys pay for. They're very, very expensive. Every time you click it, it's like a fortune. And we always hear these nightmare stories in law school, and they're all true about people that get interns that come into the law firms. And they start clicking because they think it's like, being at home. And all of a sudden there's a $10,000 bill of them just clicking garbage, looking for stuff, and it's like, you have to know how to search and you got to do it very judiciously because that is getting passed on to a client. And that's going to be a very angry client because they don't want to pay because somebody didn't know what they were doing and went on a mouse rampage. So make sure that, when you're looking at other people, you might be asked, could you look at this other expert's report and tell us what you think about it? To see if you see any holes in it, any just a face value, or maybe do a full impression on it. Go right through it and find out what you agree and disagree with and why. Check these things out sometimes if you need to. Case management, risk management, they report to me, so I know as much as they do. Osmosis doesn't work like that. It's like I could hire a mechanic, but it doesn't make me one. So we don't want that. You definitely don't want that. Membership into some type of organization, that's validatable. We can see if you're a member or not. We'll know. We can tell, and if your membership expired or something or lapsed, that's fine. But if you were never a member of the organization and we find out you lied, well, then you got a problem. You're an instructor at a college. I hope you can substantiate that, because I had plenty of people tell me they were professors at nursing schools and medical schools that they had never even went to. Some of them didn't even exist. I'm a student at the University of XYZ. Oh, no, you're not. We checked. I'm a candidate for this PhD program circa next year. No, you're not. We called and we found out that you are a liar. That helps. Professor, assistant professor. No, you're not. Clinical nurse specialist. You got to actually do something to get that. I have this degree. I have this certification. People keep records. It's 2022. A lot of things are electronic. It's a heck of a lot easier. It's not 1988 anymore. I don't have to write a letter and put a stamp on it. I can just click and call. I can chat. I can find out in a hurry. LexisNexis and Westlaw. If you go on there and and this happens to me all the time, the attorneys will punch in my name and it puts out a whole thing. It just gives me everything, like everything I've ever deposed on, places I've lived, I don't know, everything you could think of. I mean, what car I drive and whatever. They got, all kinds of stuff on there. There's tons and tons of information. They got consumer report information, all kinds of things. So, that can be done. And so if you misrepresent something, you will get in trouble. Now, I've had that happen where people LexisNexis me. And in a deposition, they said, well, what about this? You didn't list on your list of testimony that you gave this deposition. And I said, well, I didn't. Well, it says here it did. And I said, well, you're going to trust the computer? You're going to trust me? I didn't give the deposition. I guess the case settled. I don't know. I don't know anything about that. I never gave a deposition. So you're saying this is wrong? Yeah, for the second time, I'm telling you it's wrong. So there are mistakes that will be on the program. But the thing is, there's also things on there that are mistakes. So you need to make sure, because they'll come in a lot of times loaded for bear. They know a lot more about you than what you think. And that can be really scary when you're trying to navigate stuff, because they will use things against you. Like you said, you went to so-and-so school and you got your nursing degree, but that's not true, is it? Well, yeah, it's true. Yeah, but you also went to this school. Why didn't you put that school on there? Well, I just was only there for a year, then I transferred over to this school, So, they'll try to make you look bad when you're not. Yes, sir.
Like I went to school, like say we went to 10 different schools.
Yes.
School, they went out of business.
Okay.
So should you put that on your resume if you went out of business?
Well, you don't have to put it went out of business. I can right now, I could write down I was the general manager at Toys R Us. Nobody's going to find out because they're out of business. But you know what? It doesn't mean that it's not true. It doesn't mean that it can't be validated. A lot of times if you had, like, let's say you have a degree from somewhere, you have it on your wall, you can just run a copy of it. I've actually taken things off the wall and ran copies because I got subpoenaed. But you don't have to put us out of business because, for example, the nursing school I went to was taken over by a different school and it's now part of a bigger university system. So it technically doesn't exist. But it does and it doesn't because it's part of the new school. But I guess it doesn't make me an alumni of the new school. I'm not sure. But anyway, but just because it's out of business doesn't mean you have to note that, because you may not know, because there's a lot of times there's things that I don't know. So I just put down what I do know. And, maybe the high school I went to has closed down. I don't know, but I'm not going to go research it. I'm just going to tell you that's what it was when I went, back in, 1900. Are you experienced? Anybody know who this is? Oh, wow. Nice. We have a very good audience today. So are you experienced? That's another big thing. Do you have experience relevant to the case you're working on? It could be general versus, very, very nuanced issues. So if you have been working in, say, a clinic and somebody comes in with a neurosurgery case, you're probably not doing much neurosurgery in that clinic. So you need to make sure that you have a foundation to actually say something. If somebody starts quizzing you about something and you're like, I don't know, you're obviously over your head. So don't just, and this is what I see happening. The people will take these cases to work as an expert, and then they realize I messed up. I shouldn't have did this, but they don't want to tell the attorney. So they just continue with it. And the thing is, that is doing yourself a disservice and the attorney. And unfortunately, the person who got injured, you're not helping them. So if you find out that you're like, wait a minute, I just turned a corner on here and figured out this is not for me, just say so. And that way to save yourself a lot of headaches. The last thing you want to do is get in an embarrassing situation in front of a jury where they're making you look like a crazy person. So that's really bad for your reputation. Nursing home LVN offered opinion on an ICU case. That actually happened. A dialysis nurse was talking about EMS and ER. That happened. They don't have a foundation for that. So, I mean, they never worked there. And so how would they know what the protocols are? How would they know what the day-to-day environment is? How would they know about the patient care? How would they know? I guess they could watch ER on TV. I guess they could read a magazine or a book, but that's not going to make you an expert. That just makes you well-informed. Home health nurse opinion on the hospital sterile processing for the OR. People in home health don't process sterile instruments, for the OR. They don't even go in the OR. They're in homes, they're not even in a facility. So therefore, probably not the best person to pick. They may still be a nurse and that's good, but you're kind of like way off base with that. I don't know. This is a really good statement and it's underutilized, unfortunately. And a lot of times, people should have this really kind of, written in front of them, I guess, during depositions. It's a really good statement because sometimes you can't know everything. And sometimes you just don't know. And sometimes it's just better to say it. Because if you try to sit there and say, well, I think it's, on the 15th, when Mr. Smith saw Dr. Jones, he wasn't properly evaluated, was he? Yeah, I don't think they really did a good job. They could have did a better job. Really? Well, did you know he didn't see Dr. Jones on the 15th? It was actually on the 5th. I thought it was the 15th. See, don't get caught in that because attorneys will do that to you. They'll be like, well, regarding the visit on the 10th, September 10th, what did you think about this? And then you give an opinion. And he says, well, did you realize you never saw this doctor on September 10th? And it's like, you look stupid. So the thing is, if you're asked questions, ask for the document, look at it. You have the right to, refresh your memory. Ask to see it so you can take a look at it. Sometimes people are real sneaky about this stuff and they do that to discredit you and make you look like you don't know what you're doing. Yes, sir. Yeah.
I've heard this advice before too, and then I've also heard people say, if you just keep saying, I don't know, you look dumb also.
True.
What are your thoughts about that?
I think that there's a time to say you don't know something, and it's when you're being honest. If you honestly keep saying, I don't know, then you might not be the right person because you should know something. This isn't like I'm pleading the fifth. This isn't a criminal proceeding. It's a civil proceeding usually. So there should be things you do know. Here's another thing too. If you have something you're like, I'm not sure about that. I need to look at the record to refresh my memory. That's an appropriate response. I can't, I'm sorry. It was 2 years ago I wrote this report. I did reread it to prepare for the deposition, but I didn't have time to review the 3,800 pages of medical records again. So I'd need to look at that again. Could I have a moment to take a look? That's an appropriate response. Most people won't do that because they want to just answer that question. It's like quiz bowl, answer the question. And the thing is, don't play that game because you will lose. And the thing is, they'll hit you with these rapid fire questions sometimes. And, and it's pretty easy because you can manipulate people. It's not that hard. Here's a good thing. I'm going to ask all you a question in just a second, and I'm going to make you think an answer. And it's very simple. What size shoe do you wear? You're all thinking the number, you see? And so the thing is, you can have all kinds of different techniques for questioning and for manipulating where you want to go with it. So anyway, I don't know is appropriate when you really don't know. If you're like, I'm not sure, I need to look, that's a better answer. But if you really are like, I have no idea, that's not a bad answer, especially if there's no way you could know. Don't attempt to answer a question, just for the sake of answering it, don't answer it that way. Okay. Try to give the right answer. And if you don't know, you don't know. Don't give an answer that you think someone's looking for. That will get you in a load of trouble. You're trying to make somebody happy, trying to please your attorney, trying to please the other guy. I don't want the guy mad at me. Yeah, I think it's that. No, just tell him I'm not sure. I have to double check that. Don't answer without the proper documents in front of you. That's a major thing. This is something I see all the time. Experts don't ask for the documents. They're like, can I see that? Well, you were given the documents. Yeah, could I see the page that you're referring to? You're asking about what happened on the post-op from that surgery. Could I see that? Well, you don't have it with you. Well, I didn't know, I didn't cut down a tree and print all this out, but I'm sure you do. Could you show me the page you're talking to so I can look at it, please? Well, no, I don't have to provide that for you. Well, then, you know what? When you're ready to provide it, I can answer the question. I don't do well in depositions because I went to law school. And so they don't like me because I know what is going on. But most people don't go to law school and do depositions. So, they're able to kind of manipulate, bully, and, intimidate. And that's another tactic too. And it's very effective. But, at the end of the day, you're going home, they're going home. And it's no hard feelings. Like I said, they're doing their job, you're doing yours. But ask for the documents, what are you going to say? No?
Question is, it's not just a simple yes or no. Just answer yes or no.
Yeah.
And it's really, if it's this situation, it could be yes. If it's this
Yeah.
situation, it's a no. I always find that I always try to let my attorney know that, look, that's a question.
Yeah.
And so he can go through direct.
Exactly. It's give the lawyer answer. It depends. Because it does depend a lot of times, so if should this patient have been, should patients who come in with, TBI and MS and traumatic fractures be evaluated on an hourly basis? Well, it depends, some of them should be evaluated more often. It depends. So the thing is, make them qualify the question or tell them, I'm not sure I understand your question because it could have more than one answer depending on the fact pattern. So you can push it back on them and say, I'm not really sure. I'm trying to give you an accurate answer, but it does depend on some additional factors. It's not just a simple yes or no question. If they say, well, strike that, it's take that straight. He's not answering the question. Yes or no, yes or no. And like I said, you can tell them, well, I can give you a yes or no answer, but there are qualifiers. And so I've told people, and this is something I say a lot. Well, the answer is no, but would you like to know why? And the thing is, a lot of times they'll look at me and go, oh, hell no, because they don't want to know. They're like, no. And my attorney's over there smiling because he's like, oh, I'm cross. Yeah, I'm going to ask you why. Yeah, you said why. And so he's going to ask me, I'm going to give a full explanation, and they're not going to strike that for failure to be responsive. Mr. I don't know here. Ask for any type of clarification on the question. If they ask you a question and see, people are notorious for thinking while they're in the middle of something. So they're like, well, when the patient came in on the 15th and then, the doctor saw him on the 22nd, I think. Anyway, but that was before the consult. And anyway, going back to that surgery, what was it okay that they took him after surgery to that floor? Should he went somewhere else? And I'm like, I just heard like a narrative of like 7 different thoughts strung together. So if you haven't been taking your meds, please do and re-ask the question. Because the thing is, I need to know what the question is. And I told them, could you repeat that question? And they're like, have her read it back. Because they'll have the reporter read it back because they can't remember what they just asked me. Because I'm like, that's the most labyrinth looking question. That's some Alice in Wonderland stuff you got going on there. You have to get to the point. Ask me a straightforward question and we'll see what we can do. Inform them if you need to refer to the record. That the blood pressure was very high on that day, wasn't it? Well, could I see it? I don't recall. I didn't memorize all his vital signs. Could I see it? No, you can't see it. Admit when you don't know something. Opposing counsel will beat you. They'll come after you. So if you sit there and you try to just kind of fluff your way through it, you're going to get busted. If you try to just BS stuff, they are going to catch you. Some of these attorneys, it's really interesting. I guess it's very humbling that they'll get 5 or 6 of these guys to sit there and spend days and days and days to prepare to spend 4 hours with me. I don't think I'm that important, but they do this because they want to come after me with everything they can, every way they can. And I'm sitting there going, geez, you must have some well-heeled clients to be able to afford to do that. But they're really going to sit there and go to town looking for everything they can to go after this. And to have somebody sit there and spend, 8 hours of billable time to look over something I've written, that's a lot of time. Well, they're going to get something out of that. So they're going to figure out something. It's not punctuation they're looking for. They're really looking to come after you and say, well, this is inconsistent. You said this, but then you said this, and that can't be both ways, can it? And I'm like, well, yeah, it can. Would you like to know why? And then they're like, no, so, like I said, you have to really think about it. Every sentence of every expert report I write personally is there for a reason. And it's worded a certain way for a reason. And they're tied together for a reason. There's a reason why it's there. A lot of people maybe don't put that much thought into it. That's okay, but make sure you can defend it. I don't know how to improve your performance loss. always ask to review the documents if they're referring to. Don't try to remember. They're going to give you a packet of stuff to review. There's no way you can memorize all this stuff. It's not humanly possible. You can't memorize 375 sets of vital signs. I mean, that's insane. So always ask to look at it. I can't remember. I remember I saw an operative report. I can't remember which doctor it was. I mean, do you have it? Can I see it? Could we take a break and we can find it in the record so I can review it? That's what you do, is ask to see that. Yes, sir.
Answer a question like, it pertains to all the medical that you do. And you may have 20 cases in your office, and, it becomes almost like scrambled eggs after that. You
Yeah.
reviewed it, but I mean, if they say, did you remember reviewing use the example, Dr. Green's report
Mhm.
on November 11th, whatever, and I haven't seen the file again.
Yeah.
So I know.
Can you
Is there any
repeat
other
that question?
evidence or-
You want to repeat the
Yes,
question?
he's asking if you have something that I remember seeing it, but it's been a while and I can't memorize everything. There's so many cases I'm looking at, I can't remember, all of them, at the same time. You just have to say, I need to refresh my recollection. I need to look at that again. Could you show me the document you're talking about so I can take a look at it?
Yeah, but
If-
you're the expert.
yeah.
You should know this.
Yeah, well, they'll say that. They'll say, you're the expert, you should know this. And say, yeah, I am the expert, and I'm going to give you an accurate answer if you want to show me the document. Is there a reason why you don't want to disclose the document to me? Is there a reason why you're trying to hide the document? And I mean, is this what you're going to do at trial? I mean, it's like you can punch back. They don't like it, but you can. But, they may ask you, like, what was the present value or the future value on this? And you're like, well, you said it was 7.4, but it was 7.41, wasn't it? I mean, they just, it's stupid stuff. They do that a lot of times because they're just trying to do the Perry Mason theatrics. It doesn't work, and I've even told people, I said, look, you don't intimidate me and you don't impress me. You can just drop that. You're wasting your energy. But they're committed, to the role. So they just keep at it. And I'm like, I think it's just, they just know how to do it one or two ways. They just pick one way and they go with it. But you always just tell them, I need to take a look at that. I need to look at it. I tell them all the time, well, I need to see it. Well, go ahead, take your time. Go ahead, look for it. You see it? Did you find it yet? Well, if you shut up, I'd find it quicker. And I've told them that. I said, I just told you we could take a break. I said, but if you want to stay on record and continue billing for your client, you go right ahead. They don't like that either, but that's exactly what's going on. But like I said, some of them are just nasty and they got bad attitudes and they're just unhappy people. But there's that in every single profession. I'm not picking on anybody. I'm just saying there's people that get out of the wrong side of the bed some days. If you just don't know something, then go ahead and make the admission. It gives you more credibility to say, I don't know, than to sit there and make up something that sounds, well, that sounds pretty good. I think everybody would be happy with that. Yeah, till you get the trial and you see a screen the size of what you said in quotes, that looks really nasty. So like I said, it's better to save face and say, I'm not sure. I don't know what Dr. Green said to the patient's family after the surgery. I don't remember seeing that. Maybe it was in the record, but it was 2 years ago. I looked at it. I don't remember seeing it. Well, would it surprise you to know that Dr. Green told the family that the patient had their leg cut off? I don't know Dr. Green, so I don't know what would surprise me about Dr. Green. Maybe it should it? I really don't know. Well, would you agree that the doctor said that the patient needed to have a BKA? Would you agree or disagree with that? And I said, well, I don't know. I'm not a physician. If the physician said it, then that's what I'm thinking you're probably not lying to me. So if he said it and you said he said it, I guess he did. That's the way I go with it, because I'm sure you're not going to perjure yourself. But the thing is, just don't take a position that's undefensible. Don't take a position on something you don't know. Just make sure that it's something you can see. And like I said, some will try to slide in little tricks. A lot of people are really good. They just want to get your opinion. They want to see what it is. They can see what to do and how to go with it. A lot of times they're trying to see where you're at because they're trying to settle the case and they want to go to mediation. And you just see what is the expert going to say if we go to court? And if they look at it and they say, geez, this looks pretty bad for my client. Yeah, they got a strong position. We're probably going to go ahead and push hard on mediation to settle it. Or, you know what? This is pretty weak. Their expert sucks. The experts, the expert's going to be great in front of the jury because they're an idiot. And so, because they like to pick people. And, the deal is you got to look at who you're talking to sometimes with the jury. There's a thing, Verdar, where you pick out your jury. And I have a presentation, but I'm not going to do it now, about how you can go through and look at the people who are going to be on the jury, and you can tell a lot about them just from something like their name and address. You know what I mean? Really simple. So you can tell a lot about who you're going to be talking to. And you can't talk. I remember, I'm sure, I think most everybody here probably knows who O.J. Simpson is. There was a case, you might have heard about it, you know, there was some DNA involved. Anyway, so the thing is, you know, DNA analysis is not something probably that most people sit around talking about over lunch. You know, they probably don't sit there and say, you know, well, you know, we got this, you know, this double helix thing. They just don't, people don't talk about stuff like that unless you're, you know, unless you're people that I know. Anyway, but you know, like normal people don't. They're more worried about the Kardashians and, you know, real world stuff. So important things in life. But the thing is, you know, most people aren't talking about that. So when you get somebody coming in there and they got the NPR monotone voice, and they're like, well, if you take the GT and the CG and you see how they're attached, and when we unzip it with the mRNA, you know, the average person is like, I don't know what the hell this person's saying to me, you know, and they're not going to pay attention for long, and they're going to zone out, and they're going to be snoring. So the thing is, you know, you have to have the right matchup, and having a good expert, you know, that's awesome. Somebody who's personable, that's likable, you know, somebody who's not a jerk, somebody who's not mean, you know, somebody who's not real punchy. I mean, there's been cases we did after trial interviews, and they're like, why did they ask the jury, why did you vote the way you did? You know, I don't like that attorney. He was being really mean to that lady. So I voted against him. And they're like, that's how the case got won. You know, what about the evidence? It was awesome. You know, what about, I don't care about that. You know, what about the 17 dudes that got up there and talked about all this extremely detailed things with the traffic accident and the police officers? Yeah, they were fine. But that guy, he's not a nice guy. So I said, no, I don't want him to win. And I'm like going, that's what lost the case, because you're unsurly. I mean, let me tell you, your law firm's going to get rid of you. You know, so you don't know what people are going to think. But like I said, if you want to be a good expert opinion, we talked about objectivity earlier, you know, being able to just say, well, that's just the way it is. You know, I mean, you gave me the sheet and that's what it says. You know, but if you're like taking up and you're becoming part of the other team to prosecute, they're not that dumb. They're going to pick up on it. You know, I mean, I've heard people say some horrible things about juries, like, oh, people aren't smart enough to get out of jury duty. And I'm like going, you know, some of these people are really educated on the jury. And, you know, and you better be careful, you know, talking down to people that take offense to it when you're trying to get them to agree with you. You know, like I said, if you want somebody to go out to lunch with you, you might want to ask politely, you know, and so that's the way you do it. If you want somebody, you know, to do you a favor, you might want to ask nicely. You might even want to do them a favor or offer to do them a favor. But the thing is, you know, I've seen people say some terrible stuff about the juries, and you need to understand that you're going to have a little bit of everything. You know, I mean, there's going to be some people who maybe they're not catching the finer points, but you're going to have some people that can tell, like, you know, that just don't look right. I don't understand the technicality of this, but it just something doesn't sound right here. So like I said, a good expert witness, it can break or make your case. You know what I mean? A bad expert witness, you're probably not getting paid. Attorneys, you know, work a lot off contingency fees, and it's an interesting business. And they get their money after they settle the case a lot of times. If your expert witness messes up your case, and I've heard some people use some interesting strings of profanity about how they lost their case because of the expert, and it's not pretty. So like I said, you know, you're really kind of a make or break integral piece as an expert of that case. So like I said, bad client, upset client, mad client, not good for your reputation, not good for your you know, your reimbursement either. By the way, as a side note, you don't get paid for the outcome of the case as an expert. You get paid for your time. And so that's what keeps you objective. If you make any illusion or any agreement to any illusion that you're getting paid based on the outcome, you're not objective anymore. You're part of the team. So stay away from that. Document timelines. This is really important. You know, you're going to get some documents, okay? You might get them more than once. You might get them 10 times. You might write your report and then get more documents. You might revise the report and then get more documents. So, you know, it's a lot of fun. You might be getting your court notice to appear on your court date, and the day before you appear, you might get more documents. So it's important to keep track of when you get them, okay? Because this is something really fun that I like to watch when people are like, well, you know, I said that in my report because of so-and-so. Well, let me see your timeline. You didn't have these documents when you wrote this. So how did you know this? Well, the attorney told me. So you based your opinion on something that was said to you orally? You didn't have any evidence to, to make sure this was correct? I mean, somebody just told you something, you wrote a report? I mean, and that's really what happened. The attorney said, well, patient came in, patient had TBI and they had uncontrolled blood sugar and they didn't do this and this. Write me up a report about how you got to check blood sugars. And so they write up a report and then they get the medical record a week later. That's a bad thing. Hard to reference something you don't have. Listing the documents that were available and the dates, very, very important. Looking for updated versions of any of your documents. You need to make sure you're keeping track of what you're getting and when. So that way you can produce it, because that's another thing. When you get a notice of deposition, they're going to ask you for things and they're going to say, show me the documents you got on this date. I want to see just those documents. Or you know what, show me all the documents you got. I want to see everything you have. But the thing is, they might ask you, when did you receive this? That's a valid question. You know what I mean? And if you're like, I don't know, man, he sent it to me. Well, that's not a good answer. You should know when you got these things and be prepared for that, because that makes a difference. Because sometimes they're like, well, did this affect your opinion when you received these records? And you're like, no, because I already wrote the report. That's not the right answer. It's like, did you review these? Well, if he sent them to me, I'm sure I did. Yeah, that's a bad idea. I reviewed everything that was submitted to me. And I looked at that and formulated my opinions based on what was submitted.
That's a crazy question. Listing documents that were unavailable.
Yeah.
Don't know if they're available.
Well,
How are you supposed to know they're available?
I'll tell you how you list documents that are unavailable. You write the report, and then the case progresses over the course of 2 to 3 years, and you're receiving more and more stuff. And then you finally get a revised thing, some kind of revised opinion or whatever it may be, or revised statement you add to your opinion, and you list all this stuff. And then you go back and look at the dates, and these dates don't match up. So the thing is, you're telling me you had an opinion on documents that had not been produced at the time, because how you did that is you took the attorney's word. The attorney said, I got a statement. Here's a copy of a text message from the patient. And I'm like, well, that's not the record. So the thing is, a lot of times people will list in the final thing when they're going to court, here's a list of everything that I looked at. And then they go back and they look at the dates that they got it. And they said, wait a minute, you're listing things that were not available at the time you put your opinion together. So they weren't available after the opinion was written. That's how it's unavailable. You wrote your opinion first, the records came later. And then you ultimately submit a list of all records you received. Well, the records you received at the end of the year weren't available at the beginning of the year when you wrote the report. So that's the problem you have. And so the thing is, people will do that because, like I said, it's an ongoing evolution of the case. But the thing is, you have to have whatever's available to you at the beginning of the year when you write your report. That's what can be in the report. That's what can be referenced in the report. But if you have an addendum to the end of the year, and I'm just using a calendar year, for example, at the end of the year and say, here's my opinion, and you're listing all this stuff, and you're like, wait a minute, those weren't produced yet, because there's something called a bait stamp. And usually you'll see the bait stamp down on the bottom. And you can tell that's how you keep track of what the records are.
Let's just say the guy, you said, okay, the guy can't go back to work, and then you get a document the day before your trial. And Joe went, he's delivering milk at Twin Pines.
Mhm.
And, the report's done. I can't finish it now or by tomorrow or that day or whatever.
Right.
And
Yeah.
so you just put in there, handwrite it, unavailable documents.
Well, no, the thing about what's unavailable is that people are saying that they are making an opinion based on the documents that are produced, but they haven't received them yet. And so the thing is, they listed when they go to trial, they're like, can I see a list of the documents that you reviewed? And you give them the list. Okay. But the problem is you have an opinion that predates some of those documents. So you have to update it. If you update your opinion, you need to update what you're basing it on.
Ron, I think you're talking about something different. I think what you're talking about is you received additional evidence after you produced your report, correct? Yeah.
Yes.
Have it done. The attorney has it.
Yeah.
Now, going to the death or trial.
Right.
And all of a sudden, goes, well, this just changes my opinion now.
Right. And so you say, well, I'll have to go back and review that additional evidence.
But you
And
don't
then-
have time. They said, no, you got to go to death. we got it all set up.
That's fine. You go to the
No, I'm
deposition.
saying is the way I do handwrite, this document is unavailable.
If you'll let me finish, I'll tell you how I would handle it. I go into that deposition and I basically say, at the time of my report, these were the documents that I reviewed and this is what was available to me. This is additional evidence that was produced after the report. I was just made aware of that. I will proceed with the deposition, but I will then review this additional evidence and then formulate additional opinions as I see appropriate and just handle it that way.
You always leave yourself a qualifier in your report that I reserve the right to amend my opinions as new information comes available. And if you do that, then you leave that opening. Or this report may need to be amended pending the follow-up with Dr. So-and-so that the patient has scheduled 3 months from now. Always leave an opening, because that way, if you get something else, because I've had a lot of times when people gave me something, I said, well, my opinion is this. And then they give me additional information. I'm like, oh, my opinion is that exact opposite now, based on what you just gave me, because, well, that's not true. Yes, sir.
When you're talking to your hiring attorney,
Mhm.
do you have any advice on how to keep yourself objective when they're trying to kind of lead your thinking in a certain direction?
Yeah, a lot of times I just tell them, well, let me take a look at it and let me get back to you. One of the things that I do is I tell them, let me see if I can help you. If I can't help you, I'll find somebody that can, maybe if I know somebody. But the thing is, let me just look and see if I can do anything for you, because they may be asking me to do something that I just can't do. And they're like, well, we need to have a physical therapist say this. Well, I'm not a physical therapist, and they're like, well, could you say that? And well, why don't we find a physical therapist? If that's really what you want, so like I said, just tell them, let me look at it and see what I can do. I hear what you're saying. Let me take a look at the records and then circle back with them. Because the thing is, if they're telling you something like, yeah, we want to do this, and you look at the records, you're like, I can't support that. The records don't support what he's saying. It sounds good. You'll probably win the case, but I can't say that based on what you gave me. To say that, I would need this, this, and this. So like I said, leave yourself an opening to do an evaluation of the records after you've heard his spiel, and then see if they match up enough that you can opine on it. And if it's just going too far out on a limb, I just tell them, I don't see it. You would need this or this or this. Sometimes I had people talk about like, well, they didn't, the patient's labs were really bad. They didn't do anything about it. And I'm like, well, I don't see any labs in the records. So what do you want me to do? I need lab results to say that they're bad. I need lab results, and I need some kind of progress note or something to say they didn't work off of that. Well, they didn't tell the doctor. Can you show me nursing notes that say that they didn't notify the doctor? I need to have something. I can't just take your, I believe you, but I can't take your word for it. The opinion can't be based on the foundation of the attorney filing the suit, because it just is a bad way to base your opinion. Yes, ma'am.
When we're talking about listing documents that were available, unavailable, one of the things that comes to mind that I've had to educate the attorneys that I've worked with on is when we get the medical chronology.
Yes.
So the law firm has gone through all the medical records, put everything in chronology. I love that because it saved me so much time with having to go through all of the medical records. But I tell them that I need, if I see something in the medical chronology and I can't find it in the actual records they have, I tell them I need that record because I'm not going to cite to the medical chronology. Most of them get it, not all of them,
Yeah.
but just for people who haven't had that experience yet, don't cite to the medical chronology.
Yeah. If you do, validate it. That's the thing, because I've seen a lot of times where they've cited the stuff, but the problem is that the citation, what they're saying is correct, but they'll have the wrong bait stamps number, or because they updated them, or that what they're saying is correct, but it's not actually in that record, it's in this record, and that's what you have a lot of times. And it's really embarrassing to get caught in a deposition and they push and say, this is what you referenced. Can you show me where that is? And it's not there. And they know it's not there when they push it across the table to you. So the thing is, don't take somebody else's, work without validating it. Very good point. Yes. Examine the bait stamps for inconsistencies, as we just talked about. Make sure you track when you receive things and what it is you received. Just make a different document and track it. It's just easier that way, because that way when you have it, because it's a popular question, for them to ask you, and it's a pretty valid question. How can you improve on this? Make sure you accurately put your list together, update the list as new things come available, develop a timeline of the documents and when they were received, and amend your reports as necessary. So like I said, the way to get around it is to just organization. It really is just be organized on what you're getting, when you're getting, what you have, what you don't have. And that way, if, because I've had them ask me before, they said, well, the operative report didn't mention that, did it? And I said, I don't think I saw an operative report. You did not review the operative report? Well, it wasn't submitted to me. Well, I have it. Well, I don't. So the deal is, maybe you should talk to him because he didn't send it to me. Would you like me to review it? Well, if you just admitted you didn't review it because you didn't give it to me. It's like, what do you want me to do? I mean, I can only, and I've told you, this is such a common thing I tell people, I can only review what you give me. Mr. Bays, you didn't put down, my patient had a skin graft. Why didn't you put that in a report? I don't have any records of it. Yeah, that was a huge surgery, huge. And it spent weeks in the hospital. I don't have any records. Well, I mean, that's part of the foundation of the case. You didn't send me that part. Well, you should have told me. I should have told you about something I didn't know existed. And I said, talk about magical thinking. A lot of attorneys do have problems, and I won't get into it. Anyway, but the thing is, you need to really make sure that you're giving me what you want to give me, because that's your duty to do that, not mine. It's not my duty to mentally make up things that may or may not exist. That's yours. Not actively listening to the questions. Oh man, this is great. Some of the questions they ask, I'm like trying to unravel. If they ask you a compound question or a crazy question where they're kind of just rambling, just tell them you got to repeat that. I'm not really sure what you're saying with that. You told me in the beginning of this deposition to let you know if I didn't understand something. I don't understand what you're asking me. And just let them repeat it. And a lot of times they'll be like, yeah, forget that question. How about this question instead? That's what they do all the time. How about this one instead? I'm like, yeah, sure. Let's go with that. Why not? We got all day. Why not? Anyway, you must actively listen to these questions. I close my eyes sometimes when I'm listening to these people because I'm listening to this going, this sounds like garbage, and I mean, and the thing is, somebody who spent a considerable sum of money to go to law school, I'm amazed at how poorly some of these questions are worded. I've got a niece who does a better job, and she still has a diaper. Your response should be narrowly tailored to the exact question. Whatever they're asking you, if you can make it a yes/no question, answer yes or no. If it's something like, Mr. Brown, he's been in that wheelchair for a year now, hasn't he? I believe that's correct. Currently I know he's in a wheelchair. I'm not sure if it's exactly a year. Well, that means Mr. Brown, he's in a wheelchair because he has no legs. Isn't that correct? I'm pretty sure it has something to do with it. But I mean, this is the stuff they ask, and I'm like sitting there going, did you go to law school? It's just some of the things they ask is like insane. And so make sure you tailor it as narrowly as you can, and like I said, it's like, I don't know. If Mr. Brown needs a wheelchair to get, from his bed to the couch, I'm not sure. I didn't review that. I reviewed a medical record that says he's in a wheelchair. So I don't know if he needs it to get from one room to another. I didn't review any rehabilitation records or anything like that. So I'm not sure. But I do know he is in a wheelchair. So I can testify to that because I'm sure of that. If you don't actively listen, you're going to run into some issues. You can always have somebody on your side of the table rehabilitate your answer. A lot of times, don't fall for this. It's real tempting. Boy, it's tempting. It's like candy. You want to explain it. Just hold back. Mr. Brown's in a wheelchair, isn't he? Yes, he is. And that's because they cut his legs off. Well, I'm sure, like I said, that had something to do with it. And it's like, well, he wouldn't be in that wheelchair had they not did both those BKAs on him, would they? Well, I don't know. Because, I don't know if he had something that predated that would have prevented him from walking. I don't know. So the thing is, go simple as possible, yes or no, narrow as possible. Don't give a list of 10 diagnoses he could have had, which he would have also been in a wheelchair. Don't say 10 other things he would have had. Yes, sir.
How about that general question like, thank you. What do you think about
When an attorney says, well, what do you think about XYZ? I'd say, well, what should I think about it? What are you asking me exactly? What do you think about Mr. Brown's admission to the rehabilitation center in September the 15th? I think he was admitted to the rehabilitation center on September the 15th. That's what I think. They'll say stuff all the time, and I just sit there and stare at them. They look at me like I'm stupid, and I'm like, you didn't ask a question. You made a statement. What's your question? Make them ask you a question. Well, Mr. Brown's been in and out of that rehab center, and he's got all these wound care things, and That's why you're seeing Dr. Smith, right? Yeah, he's seeing Dr. Smith. I mean, but make them ask you a question. Don't attempt to offer all this extra information. You're just throwing them rope to hang you with. So stay away from that. What do you think about Mr. Brown's care? Do you think it's been adequate? Could you define the word adequate? And do you mean care by who? His primary care physician, the specialist, home health, care by who? And what do you mean adequate? Do you mean it was provided? Do you mean it was within the scope of practice? What do you mean adequate? Define all these words for me, please. I don't understand your question. They don't like that. Makes them miss lunch. How to improve your opinion. Listen very carefully. Sometimes you're thinking, yeah, I know what you're asking. I know what you're asking. Don't let your thoughts get ahead of their mouth. Slow down and listen to the mouth. Do not assume anything. If you're like, well, yeah, he means this. No, ask him if he means that. Get very specific on things. Don't let them, take you down these long rabbit holes. Be succinct. Any extraneous information or explanations you offer, they're just going to double back and get you with that. They're going to take it and beat you over the head with it. You said this, you said that, you shouldn't, that's not what happened. Well, I wasn't talking about this patient. Well, then why were you talking? You see, because that's what's going to happen. You're going to talk about some generality, and they're going to say, that's not what happened with this patient. You're not even talking. This never happened. What are you talking about? What else never happened that's in your report? Your other reports have a lot of stuff in there that never happened. It's like, how many reports have you written that have had problems? I mean, it's like, you'll get questioned about stuff. And the amazing thing about some of these depositions and all is you can walk in there and they're like, well, you went to nursing school, correct? Yes. Where'd you go? I don't know. University of Arizona. I'll just pick that. Oh, see, with the University of Arizona. So you don't like nursing schools on the East Coast? Do you think they're like not as good as the ones on the West Coast? I never said that. What I mean? It's like, but this is the type of stuff they'll pull on you. I'm using something in a very large general thing, but they'll get very specific about something like, I noticed that you talked a lot about barred catheters. Is that the only catheter you think that this patient should use? You think the other ones are substandard? I never said that. Well, did you recommend anything other than barred catheter for this person? Well, no, because I don't get to recommend it. But they don't want to hear that. They're like, no, that's what you recommended, isn't it? And that catheter is what failed and caused this, isn't it? The one that you said they should use. I never said they should use it. It's like, but this is the type of stuff you're going to wind up with. You're going to wind up with some ugly things. And you're sitting there thinking, what the hell is happening? While you're doing that, they're taking advantage of that moment, when you're not thinking, because you're thinking, well, what's wrong with this person? Then they're already on to the next question and you're trying to answer that next question. And they've got you thinking, it's like the lion in the circus. They got the chair because there's 4 points on the chair. You can't concentrate. And they're trying to get you off balance, concentrating on different things. So that way they can keep sliding things in there. And that's when you make mistakes and you say something and then they're paying attention because they're focused on you. And the thing is, and they want to know what you say because they're going to use it later after the break. And we all come back refreshed with our bathroom break and our fresh bottle of water. And they're going to say, earlier you said this. And they're going to be smiling and you're thinking everything's okay, but it's not. It's a trap. Testifying to an opinion that's not yours. Very, very common. The attorney sometimes wants you to testify to their opinion. They want you to tell the jury what they think, and they want you to be basically a extension of their bandwidth. And you have to be careful. If you're an expert, you're objective. You're telling them what actually happened. You're telling them what you saw. You're telling them what you didn't see, but you're not going to tell them what the attorney, is doing and trying to push the attorney's point, because at that point you lose your objectivity. You become part of his litigation team. Don't do this. Expert witness agrees to testify without reviewing the evidence that's documented and determine a working hypothesis of fault and only listen to the attorney's theories. So if you just have an attorney call you up and say, had a patient, this bad thing happened, this is what they did wrong, I need you to write a report. Okay. Could you send me over something to take a look? Yeah, here's some records. I Frankenstein them together. Here you go. Might not be a good idea. See what you have in front of you and see if what the person says to you on the phone matches what you read in front of you. Sometimes it will match. Sometimes it won't. Sometimes it kind of matches, but it's up to you to do that because that's, at the end of the day, it's your reputation. Who cares if the attorney goes home and he's got a good reputation, bad reputation? It's not yours. It's your reputation. And you don't want to walk around with people saying, oh gosh, not this person again. I've had people in the legal community and they're like, oh man, I've had so-and-so. Yeah, she came into oh yeah, I had her again. oh, I hate deposing her. You know, I mean, people get reputations. They do. And you'll know, especially if you're in a certain region, you know, and you'll hear them complaining. And it's like, oh yeah, oh so-and-so, oh man, she's great. Yeah, we were in and out in an hour and a half, you know. And I'm like, oh, I like that because I got places to be, I got things to eat. So, you know, that's the way it works. Likewise, don't be negligent in not learning enough about the case before determining whether you have the experience, interest, and ability to be an effective witness in the case. I've had cases I have no interest in. I'm just like, you know, this is just, you know, you look like a nightmare to work with. I don't want to deal with you. You know, one of the most entertaining cases I ever had had a couple of guys from New York, and they asked me to work on this case, a couple of attorneys in Oregon. And they asked me to work on the case with the guys in New York because they couldn't talk to them. Because the guys from New York were screaming and cussing and going berserk on the phone, and the people in Oregon were horrified and they couldn't understand what was happening. So I was the interpreter. And so I went between them. So I had a great time. The two guys from New York and the guy from Jersey, we had a wonderful time. I mean, it was just a lot of fun, a lot of screaming, you know, it was a lot of fun. You know, I mean, we just had a good time on the phone. Then I dialed it down, called the guys in Oregon and said, well, we're probably going to pursue this theory and this is what we're probably going to do. And they were like, okay, that's great. Thank you for talking to them because they're a little bit difficult. You know, it's like, and I'm like, yeah, I understand, you know, and same thing, you know, I worked with somebody in Kansas one time. I had to dial it down to a 1 with them because they just were like very, very, very timid with how they were dealing with things. Very polite and very nice, you know, because it was a real joy, you know, to work with people that are actually professional and courteous and not ugly. You know, and like I said, a lot of times you walk in, there's some attorneys, I get deposed. I'm like, oh gosh, not this guy. And they come in and they're just like, you know, it's just all hell's breaking loose the minute they walk in the room, and it's not going to stop till they leave the room. And, you know, and it's like, you don't want to deal with that if you don't have to. Try to keep things even keel. Don't get amped up. Take your time answering, you know, don't feel rushed. You know, sometimes they're in a hurry and they're trying to push you because I got to get to the airport. And it's like, I understand that, but you know, we also need to do our job. And so let me give you the answer that is the answer. And then on the plane, on the airport, you can decide about how you're going to do whatever you're going to do. But like I said, just don't get caught in those traps of testifying to things that people want you to testify to. Or, well, the other expert wouldn't do this. I need you to do it. Okay, you got my attention with that because what is it this person won't do? You know, I mean, so it's, you know, I'll do anything but love, but I won't do that. You know, I mean, it's like, it sounds like a Meatloaf song. So I want to know what it is this person just flat out told you, I ain't doing this. And so that's concerning. And sometimes, you know, there's a good reason. They're like, well, they don't have that certification, but you do. Okay, fine. You know what I mean? Or, you know, well, that looks pretty unethical. Okay, you know, well, if it's unethical to them, it most likely is going to be to me too, but let's take a look. And, you know, it is sometimes. How can you improve your performance on this? Review all available documents, evidence, files, look at everything you have, determine overview of the facts. Make sure that you kind of map out rights and responsibilities of parties involved. Try to look at everybody, you know, where they're doing, where they're going with things. You know, it kind of gives you an idea, overall roadmap. Examine your qualifications to testify on the matter. Identify any friction between your assessment and your client's theories or assessment. If you have some serious friction between you and what you're coming up with and what they want you to do, this might not be a good fit. You might want to just like push that retainer check back over and say, you know, I don't think it's going to work. I've refunded money plenty of times because I'm like, this is a bad match. This person's insane. And, you know, I don't need more of that. I need less of that. Sometimes, like I said, it's just a personality issue. This person is, you know, bouncing off the walls, and I don't have the energy to keep up with this right now. So I need somebody who's a lot more mellow. So I just can't do this right now. I've already got the full desk. You know, nothing personal, just not a good match. There's some attorneys I love working with because they're a lot of fun and they're good people and they just, it's straightforward, you know, it's no problem. There's other people you're like, oh man, this guy's going to ask me all this stuff and he's going to badger me and badger me and badger me and badger me. And I just don't have time to hold his hand on this because I can tell you, I've had a lot of attorneys that contact me. They're like, I've never did this before. And I'm like, practice law? And they're like, no, I've just never did a case like this before. It's the first one. I'm like, oh gosh. All right, let's take a look at it. You know, and then I get calls like, I'm going to file a motion to dismiss. How do I write that? And I'm like, well, you go back to your second year in law school. And, you know, that's where you learned. And, you know, it's like I said, you just got to know who you're dealing with and if it's going to be a good fit for you. Sometimes there's even like cultural and language barriers. You know, I've got a bunch of people from certain countries I work with because I can understand them. I don't speak that language, but I can understand what they're saying. But, you know, there's my colleagues are like, I can't communicate. I don't know what they're on the phone. I just hear this. I don't know what's happening. And so that's a valid concern. You know what I mean? So that's part of it too. Question for audience.
Yeah, how would you handle this? Where a judge tells the jury, don't listen to this expert or the other side's expert. They don't know anything. And you're one of the experts.
When you're dismissed, you leave and go home. That's how you handle it. You just leave and go home. You
Oh,
know,
you mean you would leave and go right after he said that, or
no,
wait
no, no,
after?
no. When you're dismissed, and you're allowed to leave and just leave and go home.
Oh, I mean, after you get cross-examined and,
Well, yeah, when you're
direct. No.
after you're
Oh,
dismissed.
okay, that's
yeah.
what I did.
Just
I'm
finish up and do that. Let me.
I never had a judge do that. I thought,
Well, welcome to clown world. Let me tell you how courts work. I'll give you this for free. There's nurses out there that lecture a lot about federal rules of evidence. This is how evidentiary procedure works. These are the civil rules of procedure. You know, and you'll hear all this stuff. You know, nurses, unless they went to law school, they went to nursing school. You know, vice versa. You know, lawyers don't go to nursing school typically. Some of them do. But the thing is, you know, the nurses I see lecturing all about this. It's factually correct. Here's federal rule of evidence 7.1. It's factually correct. But let me tell you the real world. When you walk into the court, whatever the judge says, that's the way it is. You know, I was prosecuting a case. I said, objection, hearsay. Yeah, we want to hear it anyway. Let's see what he says. You know, objection, Your Honor, that's hearsay. Yeah, I know. Let's hear it anyway. You know, this is how it works. This is real life. You know what I mean? They don't care. It's like whatever's going on in that court, you know, that I spent freaking years studying these rules for, they just suspend it and do what they want. And if you think that you're going to get that overturned, you're crazy. Because, you know, I always say you can solve most problems in this lifetime with enough time and with enough money. And those are the two factors, but you got to have unlimited amount. The thing is with courts, they're going to decide what they want to decide. They're going to exclude what they want. They're going to give instructions to exclude. And sometimes you can have a review and have the decision overturned. Sometimes you can't. Sometimes you can't afford it. You know, this is a very, very expensive field. It's not cheap. If you want to litigate, you got to pay to play. And the thing is, a lot of people are like, you know, I don't want to appeal it because the cost of the appeal outweighs the amount of money they reduced my judgment. And it would actually, I would lose money appealing. I'm from New Orleans originally. And so Louisiana is the only state out of 50 that has a different set of laws. They do Napoleonic law, not English common law. And so it's very, very different there. And if you've never been to court in Louisiana, you're in for a treat because it's a very interesting place that even the movies can't even capture the magic of. And so when you go to, you know, and I'm not saying this to be ugly or anything, I'm just telling you the reality of how I grew up. You walk into the courtroom and this judge, he runs the place and whatever he says is the way it's going to happen. Where I went to law school, I went into the court with a colleague of mine to deliver some papers. And I watched the judge sit down. He listened to somebody make a very eloquent argument. And I was like, very impressed. I was like, that's incredibly articulate. I watched him bang the gavel and laugh. He said, guilty, innocent, you're all gonna pay. It just banged on the gavel. And you know what? That's the rule. Everybody that comes in there is paying. And it's like, I'm here to pay a fine. Well, here's your court cost. I'm not going to court. I'm just here to pay a fine. You're paying it. That's the way it works. You know, if you think that you're going to go and follow the rules in the textbook, you're mistaken. So when you go to a courtroom, whatever the judge says, that's the way it's going to be. And the thing is, it's not up to you as an expert. You're just there to play your role. And your role is to deliver information. You're the messenger, you know. You're there to deliver the information, and you're not there to decide the information. The trier of fact, usually the jury, sometimes it's the judge or a panel of judges, they decide. And they also decide something else. They decide your credibility. So they decide if they think they can believe you, or if they think that you're up there just mimicking what the attorney wants, or if they think that something's going on. Now, the judge here is telling these two people, I'm beginning to think that both of you are lying to me. And I think he's right. The jury, they get to judge your credibility, as I just said. If they don't believe you're objective, you're just part of the litigation team. That's how it works. So the thing is, you have to have some professional demeanor and objectability to the information and present it in that way, or they're just not going to take you seriously. And if they don't take you seriously, and especially if they don't like you, if they just don't like you, you got a problem. There's some people that have just been downright ugly as experts. And I'm like, hey, back off of that, just remain calm and answer the questions. It's your attorney's job to change the answer. If you don't like the answer you're giving, your attorney will rehabilitate it. They may choose not to. They may choose not to vindicate you and let you say something that you're like, that's wrong. And you just have to be quiet and allow them to continue the case. It's their case. It's not your case. That's their case to try. It's their responsibility, not yours. Thank goodness, right? So that's what you have going on. But like I said, at the end of the day, the juries, the courts, they have their rules, but those rules are subject to suspension and modification per the judge's will. And like I said, there's some areas where I went to some extremely off-center rules, and I want to put it nicely, and you still can have a good outcome. But if you think you're going to get everything your way all the time and it's going to come out perfectly, that's not realistic. I've seen a lot of people walk in that had a good case and they walked out with nothing. I've seen some people walk in, they're asking for X and they got 1/3 of it. And I'm like, that's actually a pretty good deal. It's just unfortunate sometimes, but your role is to make sure that you are looking at the information, delivering the information to whoever's looking at it, and you're giving them a good review of the information and not trying to push aside on this. We got some question time. I'm going to let you guys ask me any questions. I'm on LinkedIn if you guys want to connect with me on LinkedIn. Some references if you really have nothing better to do with your time. You can look that up and read some of those cases, which will definitely put you to sleep, no doubt. Yes, sir.
I'll try to be brief since it's the last one today.
Oh.
I think I can set the stage in about 15 seconds.
Cool.
But we had a serious motor vehicle accident. The guy was in a Miata, rear-ended by a drunk, et cetera, et cetera. He was making over $1 million a year. He had a pretty significant head injury. And at the time I interviewed him, he was training his replacement. I put it in my report, found him permanent total for all practical purposes. He couldn't do his job at all. The judge read my report, told the attorney I was working for that if I gave any information about him training his replacement, I would not only be held in contempt, but I would be put in jail for at least 2 to 3 days. Understanding that, I went to court. I was naturally hesitant to say anything, but I was ready to go to jail. Questions came up to me and I would always respond. If I needed to enter that information into my testimony, I would always answer, I'd love to answer that, but I don't want to end up in jail. And the jury's looking at me like, what are you talking about? And the jury knew that somebody was holding information for them. And I never did get it on the record. I never went to jail, but the questions were posed to me in such a way that it would be very difficult for me to enter.
Yeah.
So I tried to do my best job for the jury, and my hands were tied.
Yeah. First of all, everybody in here is way too pretty to go to jail. Don't go to jail. The thing that you have going on is you have a client and you're trying to do what you can for the client the best you can. Sometimes there's going to be constraints. Even if you were allowed to testify and give all that information, the judge still has the option to tell the jury and give them an order and say to not consider that information. So even if you had just given the information and gave out handouts to the jury, they still can be told to disregard it. So, again, it's a tough situation. You want to do the right thing, obviously, and you want to give people the information that they need to have to make the decisions, but it could be excluded on the front end, the back end. There's lots of points that can be excluded. Regardless of what you do, it can be taken out of the mix. So unfortunately, like I said, that's kind of what I talked about with courts. Some of the courts you're going to go to, they're very straightforward. There's no problem. But you have to kind of work within the rules too, because there's a certain decorum of the jury, the courtroom in front of the jury, and we have to follow that. And so there's certain things that we don't bring up in, like, say, a medical malpractice case, like insurance. We're not allowed to discuss that. And a lot of times the jury's thinking, well, I don't want to bankrupt this poor doctor. And it's like, well, the insurance is going to pay it, but we're not allowed to tell them that, or the collateral source rule, things like that. So, unfortunately, there's all these extremely complex rules. And then if somebody misinterprets them, or even worse, they try to shade them a certain direction or another direction inappropriately, then you get some weird things. But there is recourse. Your attorney does have the option for appeal. And in an appeal, you can have a new review of the case, and you could probably present your your information there. But like I said, it's all strategy. And I would say that if you're in that situation, my best advice is to talk to your attorney about it and see what you guys can strategize with to do things within the boundaries of the rules, because you don't want to break a rule, but you also don't want to like not give people information they need. So the thing is, your attorney is in the best position, the driver's seat to give you advice on how to proceed with that. And that's really part of his job, is to figure out how he gets information from you to these people. So like I said, that's up to him. And some people are more successful than others.